Guardian disability appeals are challenging, and they're challenging on a variety of fronts, which we will get into in this video. And people have to do these appeals because they've been denied their benefits, assuming they have a ERISA governed policy, which is an employer provided policy. And certainly we represent tons of people who have individual disability policies, but even with those, we may not rush to file a lawsuit because we probably want to get additional evidence into the record, which may not be allowed if we file a lawsuit. So we'll focus on the basis that we're doing an appeal, whether it's ERISA or an individual disability, which Guardian writes those policies through Berkshire. So Caesar, when you're going to attack and I say attack because that's the way I feel, is we're attacking the company for wrongfully denying someone's benefits. But when you're going to start out with this Guardian claim to do an appeal, what are the steps that you need to take at first in order to give someone, a reasonable opinion to say, hey, this is the plan of attack that we're going to take to win this thing?
Well, it starts with the very first thing we request, which is usually the claim file from Guardian. And also, look, depending obviously if we're approaching it as a ERISA appeal or, just another bite of the apple on an individual disability denial where they've offered an appeal, you're going to get different information out of that request for that administrative file, out of that claim file, depending on what it is. But assuming it's ERISA, okay, the reason we really want that, that administrative file, that claim file, is because it's going to contain every piece of documentation, every report, every memo, possibly every summary of every phone call you've had, even though they say they record their phone calls. Right. I don't know how they record the phone calls, but certainly they have these notes in their file that summarize the phone calls they've had. Certainly every piece of documentation you gave them. But again, importantly, those reviews and the reports from their internal medical teams or their external peer reviews that have conducted a medical review of the file and your records. And really without that file and without those critical pieces of information, it's going to be really hard to approach the appeal or attack the denial, right?
And so, Stephen, that leads me to somewhere where I usually start when I talk about these things, is that sometimes some people from Guardian will convey to the person, they'll call them on the phone, or the person will get the letter and call them and be like, hey, I got denied. And the person on the other side of the line will say, well, you have an opportunity to appeal this, just go ahead and do an appeal. But they don't say anything about the importance of this appeal. Talk for a minute about why it's so important to do an incredible appeal in order to give yourself a chance not only to win this appeal, but to protect yourself if you lose the appeal and have to file a lawsuit.
Yeah. Following a denial, the appeal, like we usually say, is more important than even the lawsuit, in the sense that the lawsuit is predicated upon what's in your appeal. You get one opportunity to appeal under the law. You have to go through that process before you can file a lawsuit. So like you said, the claims manager or analyst will say, hey, just submit an appeal and we'll review it to look to, reinstate the benefit or approve the claim. And they don't explain what's at stake, right? So say the person does go ahead and submit their own appeal, and all of a sudden it's just a quick turnaround rubber stamp. We've reviewed everything. We're upholding the denial. As of that final denial, you can't bring anything new into your file to be considered in court. So your appeal is your last opportunity to really provide as much additional, medical information, vocational information, ancillary stuff like personal statements, articles, whatever the case may be. The information you use to not only try to win the appeal and get on claim, but also to increase the likelihood of success in court if it goes there, or even settlement offers and mediation during the course of litigation. So the appeal is going to dictate how your claim is going to go for, potentially till Social Security retirement age, right? And you get 180 days, and usually when there's been a denial, there's been some time. Either they haven't been getting paid because it's denied on the initial review, or all of a sudden their money flow's done and they want to rush the appeal to get it done. 6 months is a long time without money, but that 6-month period could be setting forth 10, 20, years of potential future benefits. So you have to take it very, very seriously and make sure it's very diligent and very, logical, analyzed approach in providing information to get your claim approved.
Caesar, a lot of people call and they go, I don't understand, I sent them everything. What more could I possibly, show Guardian in order to convince them that I'm disabled? And that's where I know all of us look at it, because we're coming from the frame of mind as, how does this look to a judge down the road? What do we have to prove to the insurance company, but also to convince a judge down the road. Something that it is absolutely impossible for a claimant who's been denied, unless they're a lawyer who does this kind of work or they've been involved possibly in a denial before, that they would know. So when Guardian says, hey, you have the opportunity to appeal, go ahead and send us more information, nobody knows what that means. They can't possibly know. They don't know the thousands of cases that we've read out there that talk about what information you need in order to prove your disability, what's reasonable for an insurance company to review or not review. So what strategy and tools do you use in order to prove that a person's disabled? And obviously it depends on the medical condition, but answer this question generally about how you get additional evidence to help a person win their appeal.
Yeah, so again, we're always analyzing kind of the whole body of work here with medical records, with what's within that claim file. Obviously, going through all of the reasons and the basis that they're denying the claim. They're saying that this information is lacking. It's interesting because ERISA actually requires them to identify and tell the claimant what pieces of evidence are missing and what can you provide that will assist us in reviewing your claim and potentially, paying your benefits.
And I love that you said that, but when have either of you guys ever seen in a denial letter where they say, send us A, B, C, D, and E, and that will help you prove?
Generally, it's just a catch-all thing. Send your updated records, any additional testing, and they'll list a bunch of stuff. Yeah.
So what I have seen, their approach is, you don't have this type of testing to prove this. You don't have this type of thing to prove that you have any objective findings. You don't have this, you don't have this, you don't have this. That's their kind of roundabout way of telling you, well, if, these are the things that might help us find that there's objective proof or evidence of your claimed limitations, of your condition, of your symptoms. But that could mean additional neuropsychological testing if you have cognitive impairments and limitations. That could mean functional capacity testing if you have physical limitations. So things that could potentially, place into some sort of empirical data form, for them. Here's setting out. I mean, nobody really approaches, and doctors certainly don't. Your treatment providers aren't thinking about, documenting your medical file to support your disability claim. They're not doing that.
Right, of course. Doctors are doing the bare minimum because the insurance companies are beating them over the head saying, we're only going to pay you X amount of dollars. The doctors can only spend so much time with the claimant, and the doctors have a relationship with the patient. They've been seeing these patients many times, and so if you go in, Caesar, doctor's like, how are you today? Looks at his notes, understands, has a relationship with you, and then you go in and you might say, and here becomes a problem, I'm okay today. Well, what does okay mean? Okay means I'm a 6 today on my pain scale or on my brain fog or whatever's going on with me, whereas some days I'm a 9 or 10. But a normal person should be a 0 on the scale of basically being, I have no complaints whatsoever. But for you, if you're the patient, you're happy to be at a 5 or 6. So what happens is then the insurance company gets those medical records and they look at it and go, you went in and told the doctor that you were feeling okay. I'm feeling okay as what I understand as my new life, my new baseline of suffering, being fatigued, and every other element I have. So that becomes a problem. But Stephen, what is special about what our law firm does, and especially with physician statements, to work with doctors to communicate in what I call playing the game with the insurance company, getting the evidence in front of them in such a way where they're almost forced to agree or come up with a very strong reason to disagree with the evidence presented?
I think it's through all the years of experience in doing it and understanding how you build your information, right? Like Caesar was saying, any objective testing you can use to support subjective complaints, because Guardian's always going to attack the subjectivity of your complaints. So providing objective testing to verify those subjective complaints, taking those in conjunction with the reviews done by their medical personnel, right? And then we do, individualized attending physician statements for the doctor, because what you'll generally get from Guardian is a one-size-fits-all proposition. And a lot of times doctors don't know, like in a back problem, well, how much can your patient lift? 10 pounds, I guess, And they could set it up to actually get a denial because Guardian's working on that idea of Department of Labor standards. So getting all this information and then presenting it to the doctor so the doctor really has an understanding. And the subjective testing, if a doctor is unsure about how to support his opinion, always relying on that new testing. And I think one of the big aspects of it is always making sure that the doctor understands that this idea of disability is tied to occupational ability, whether your own occupation or any occupation, depending on the definition of disability, that this has nothing to do with activities of daily living and things of that nature. Really kind of focusing and keeping in the medical impact on, you know, the vocational side. And one thing I personally do in all my letters I send to doctors asking for opinions is I also advise them as to the nature of the area of the law, right? ERISA. Because some doctors, I think, get a little kind of hesitant because they're like, lawyers are now involved. Am I going to be deposed? Am I going to get called into court? You know, so I also let doctors know that they're never going to be deposed. They're never going to testify in court. The only thing a judge would ever consider if it gets that far, written records and opinions, right? So, you know, they don't have that fair. And then also kind of be like, oh, by the way, peer review doctor, you know, whoever, never examined your patient, spoke to you, and is basically saying you don't know what you're talking about. How do you feel about it, and how do you want to respond? So it's really coordinating with the doctor, helping them see how the game is played in the sense of responding and all that type of stuff. So it's really kind of a holistic approach, and you start with your base of information you want, and then you just keep getting more, you know, detailed with it.
Yeah, I like claimants to understand that we're going to take all the information that we gather, whether it's medical, vocational. We may work with a vocational expert. If not, we're going to establish what the standards are for that occupation or any occupation based upon experience, education. And we're going to present it all in a manner that's very strategic, because we don't want to tell the guardian every single thing that they did wrong or need to do, because then if they go and do that and they do a reasonable review, we've now screwed the client for the lawsuit. So we have other videos where we talk about guardian lawsuits, and I encourage people to watch that also so that they know what's the next step if I were to potentially lose this appeal. How does that go down? So if someone's out there with a guardian disability denial, feel free to call any of our lawyers. No matter where you live in the country, we're going to provide you with an immediate free phone consultation. We never charge you any fees or costs unless we recover money for you. So we look forward to the opportunity to discuss your claim and learn how we can help you to get your benefits paid.